We live in a world where crime is increasingly transnational. In this environment, how do we manage the tension that can exist between respect for the rights of the individual who is being brought to justice and respect for a foreign state system of law? Consider this scenario. As counsel for the Attorney General of Canada, I prosecuted an extradition case involving two young Canadian men, Sebastian Burns and Atif Rafe. They lived in Vancouver, British Columbia. They traveled to Washington State in the United States, to the home of Rafe's family. While they were there, they murdered Rafe's mother, sister, and father. Immediately after the murders, they returned to Canada. Once the police investigation had concluded, the United States requested their extradition to be sent to Washington State for trial. The Canadian courts found that there was sufficient evidence that they had committed the murders to justify ordering their extradition. But there was one potential and very important obstacle, and that was, if ultimately convicted, Burns and Rafe could be executed. Canada is an abolitionist country and has been so for decades. The question for the Supreme Court of Canada, which was the body that ultimately had to decide, was whether international norms among similar countries were such that extradition to the death penalty could not be justified under Canada's Charter of Rights and Freedoms. One of the things the court had to consider was that 10 years earlier it had upheld the extradition of two individuals to face the death penalty in similar kinds of cases. The Supreme Court finally did decide that in the intervening 10 years, international norms had changed, had evolved such that extradition to the death penalty could no longer be justified. And it said that before Burns and Rafe could be sent to the United States would have to give Canada its assurances that if they were convicted, they would not be executed. After the Supreme Court's decision, the United States did provide those assurances. Burns and Rafe were sent to Washington State, were tried, convicted, and are presently serving life sentences. This is just one example of the interplay between law and morality, where hard choices have to be made. Governments and courts have to balance the human rights of the individual with the legitimate interest of states to investigate and prosecute crime. Every country has its own standards of human rights and civil liberties and protections under its own local law. But modern communications and technology have created a truly complex global village. This means that while we can have our own standards of what we think makes for a just legal system within our own borders, we should not take a parochial or chauvinistic view of those standards. No country has a monopoly on the perfect legal system. No country has a monopoly on the pursuit of justice. As the world continues to globalize, our concepts of justice will also evolve. We will have to strengthen tools for international legal cooperation. We will have to work together to communicate and to cooperate as truly global partners. Thank you.